on these violations, which we have alleged, in which the defendant has entered a plea of true to, we respectfully ask the court to adjudicate him and sentence him in accordance with our plea agreement, which is for 2 TDC.
Okay, let me ask you, how many counts are you showing? The docket is showing 12 counts. How many counts are you showing?
How many counts, like, did he plead guilty to?
Yes.
Let me check.
Ms. Lerma, do you happen to have that information?
Yes, Judge, I'm pulling it up as well. Although my computer, of course, is acting up right at this moment.
Your Honor, it was 6 counts.
Okay, I was showing 12, and so I just wanted to make sure.
6 is
It
correct,
was
Judge.
12 total, but he pled guilty to 6.
Okay, so 6 counts. All right. Ms. Lerma, is this your understanding of the plea agreement?
Yes, Judge.
All right, and have you had a chance to review portal and all documents tendered to you?
Yes, Judge, I have.
All right, Mr. Dorth, is this your understanding of the plea agreement?
Yes, ma'am.
Okay, understand that it is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of true. But if I follow this plea of true, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court.
Okay.
Do you understand that?
Yes, ma'am.
All right. Based on your plea of true and the evidence introduced, I will accept your plea of true at this time and find that the evidence substantiates your guilt. I will go ahead and find you guilty of 6 counts of fraudulent possession of a controlled substance, Schedule 3, 4. And I will assess your punishment at 2 years in the Institutional Division of Texas Department of Criminal Justice. Your sentence will commence this day, and you will be given credit for any time that you may have spent in jail on these charges. I believe this is what Ms. Lerma said that she wanted to address at this point.
Yes, Judge. Mr. Duarte has also done his required time at BHRTC, and he's asking the court to take discretionary notice of that time, and that time, which he successfully completed at BHRTC, be credited towards his time of service.
Okay, 2 questions. Ms. Pineda, did he successfully complete BHRTC?
Your Honor, he did complete the BHRTC inpatient part of the program.
What do you mean? Was he assigned outpatient and he didn't complete the outpatient?
When they complete the actual BHRTC, they have to complete the outpatient aftercare part of it.
And did he complete that?
That's when all these issues started coming upon, he relapsed and all that. But if I may provide the court with the actual dates that he was in BHRTC, in the event you do want to grant those dates.
Not if he didn't complete it, Ms. Pineda. I mean, he needs to successfully complete the entire program.
Judge, for purposes of the record, could she just provide us the dates so that I could also have a chance to, or Mr. Duarte can know what dates he was there?
Go ahead, Ms. Pineda.
The dates were from April 29th, 2020 through October 23rd, 2020.
But he did not successfully complete the program, correct?
So he did complete the actual inpatient BHRTC part of it, Judge. It was the aftercare part of it, which is when they're out of the facility and reporting to regular supervision. That's when he started encountering the issues he is currently in custody for.
And Judge, we would just, I didn't know that difference, but we would ask the court to consider his inpatient portion of time.
I believe he has to complete the entire program, Ms. Lerma, is my understanding. And I believe the entire program consists of the inpatient and the outpatient. If you want to provide me with something that tells me that, but I believe it's got to be the successful completion. Okay.
Very well, Judge.
All right. So at this point, he will not be given credit for his time in the BHRTC because he did not successfully complete it. All right. All right. Anything further from the state?
No, Your Honor.
All right. Ms. Lerma, anything further?
Nothing further, Judge, from the defense.
All right. All right.
Your Honor, if I may, Ms. Lerma has a writ of habeas corpus also on the docket. And I only bring it up because she's here on the screen. The case was screened. It was supposed to be presented. Well, the underlying case and where they filed their writ was screened and was supposed to be presented to the grand jury today. However, we did not have a quorum. So we won't be presenting any evidence on her writ.
Is that on Mr. Duarte?
No,
Uh,
Judge, that's a different case. I was
Different
just,
Okay, well, then let me just make sure that we're covered on the fact of Mr. Duarte. Mr. Duarte, your sentence will commence this day and you will be given credit for any time that you spent in jail on these charges. All right, anything else from the state or the defense on Mr. Duarte's case?
No, Your Honor.
All right.
nothing further, Judge.
All right, Mr. Duarte, you'll go ahead and be fingerprinted there at the jail. So they'll give you more instructions in just a second, okay?
Thank you.
All right. Now,
It's on page 15, Judge,
okay, who's next?
in reference to Ms. Lerma.
The
Eduardo,
writ of habeas, okay. On Eduardo Luna, is that the one?
Yes, Judge.
Yes, Your Honor. And I apologize for interrupting. I thought that matter had been concluded.
No, it's okay. Okay, so Ms. Lerma, what's going on with Mr. Luna?
Well, Judge, just as Ms. Rutledge said, is that he's got other cases pending in the 41st, but this P-file case that he has, we filed a writ because nothing has moved on it, and we can't do anything with his other cases. So I filed the writ because we needed to have some sort of either indicted or to be dismissed or something in order for us to be able to move forward.
Okay, what kind of P file is this?
It's a P file. We now have it in our office, Your Honor. It was for, help me, Ms. Lerma, was it an assault on public servant?
Yes, a second-degree assault on public servant.
All right, Ms. Lerma, go ahead and get me your order and I'll grant your writ.
Okay, Judge, I'll send it over.
Ms. Rutledge, you sure you're not going to provide anything right now?
No, Your Honor, I'm not.
Okay, Ms. Lerma, go ahead and provide me with your order, please.
Yes, Judge, I will. Thank you.
Thank you. All right, Mr. Serna, what's next?
yes, ma'am. We can get that one plea that we only have left and we can do the rest.
Okay, which page?
Page 14, that's Moises Martinez.
Okay.
With Christopher.
And who's representing? Oh, Christopher Hernandez?
Yes, ma'am.
Okay, Mr. Hernandez, thank you for your patience. Are you
No problem.
ready?
I am, Your Honor.
Okay. All right, and let me pull up the plea papers. Give me 1 second. Give me a second. I know they were sent to me. Give me 1 second.
For Martinez, they're now in the system also, Your Honor.
Okay. Okay, not going on the record, but just double checking. This is 2019 5859.
Yes,
It's 3 counts of injury to a child. One's a first degree, 2 are third degrees. Is this the right case?
Yes, Your Honor.
Before we call it? Okay, and we're looking at 5 years TDC? Is that what we're looking at? Yes?
Yes,
All right.
that's correct.
All right, let's go ahead and call the case, Mr. Serna.
cause number 2019-0D0-5859, State of Texas versus Moises Martinez. May I have announcement of counsel?
Sarah Rutledge for the state. State is ready, Your Honor.
Christopher Hernandez for Mr. Martinez, we're ready as well.
Right? Mr. Hernandez, do you see your client on the Zoom windows?
Yes, Your Honor.
Okay, is he at the Zoom window labeled annex?
That is correct, Your Honor.
All right, Mr. Martinez, would you please raise your right hand? You swear to tell the truth, the whole truth, and nothing but the truth, so help you.
Yes, Your Honor.
All right. Mr. Martinez, would you please state your name, date of birth, and whether or not you are a U.S. citizen for the record?
Moises Martinez, July 5th, 1986, and I'm a citizen.
You are a U.S. citizen? That's what I heard?
Yes,
Okay. Mr. Martinez, you are charged with 2 counts of injury to a child with injury to a child or elderly or disabled. First count is a 1st degree, second count is a 3rd degree, and the 3rd count of injury to a child is a 3rd degree. Are you aware of these charges?
Yes, Your Honor.
All right, and do you understand that you have a right to remain silent, a right to trial by jury, right to counsel, right to confront or cross-examine witnesses, a right to call witnesses on your behalf or in your defense?
Yes, Your Honor.
All right. Have you, and do you understand that by proceeding in this hearing, you are waiving many of these rights?
Yes.
Right. Mr. Hernandez, have you had more than 10 days to prepare for your defense in this case?
Yes, Your Honor.
All right. Mr. Martinez, I have received plea papers that have a signature on them. Is this your signature?
Yes, Your Honor.
All right. And do you read and understand, did you get to read and understand the plea papers?
Yes, Your Honor.
All right. Mr. Hernandez, did you explain the plea papers to your client?
Yes, Your Honor.
And do you think he understands the admonishments, the rights, and the consequence of giving up these rights by entering a plea in this case?
I do, Your Honor.
Mr. Martinez, are you satisfied with your attorney's representation of you in this case?
Yes, Your Honor.
All right. And Mr. Hernandez, do you have any reason to believe your client is not presently competent to enter this plea?
No, Your Honor.
Mr. Martinez, have you ever been found incompetent by a court or examined by a doctor or psychiatrist who has found you mentally ill?
No, Your Honor.
All right. Based on your testimony, your attorney's representation, and my observation, the court finds that you are competent to enter your plea. You previously stated you are a U.S. citizen, correct?
Yes, Your Honor.
Okay. Understand that if you are not a citizen of the United States, a plea of guilty and a finding of guilty may result in deportation, the exclusion from admission to this country, or the denial of naturalization. Do you understand that?
Yes, Your Honor.
All right. Based on the fact that you are competent and based on the fact we've determined your U.S. citizenship, to the charge against you, what is your plea?
5, Your Honor.
I couldn't hear you, and I don't think the court reporter could hear you.
I plead guilty.
Okay. And I believe the court reporter was able to hear you plead guilty. All right. Mr. Martinez, are you making this plea freely and voluntarily?
Yes, Your Honor.
All right. Ms. Rutledge, please summarize the evidence.
Your Honor, had the state proceeded to trial, it would have presented evidence through witness testimony and other competent evidence to prove beyond a reasonable doubt that the defendant committed the acts alleged in counts 1, 2, and 3. Count 1 being injury to child, elderly or disabled, intending serious bodily injury or mental injury. Count 2 being injury to a child, and count 3 being injury to child, elderly, disabled with intent bodily injury. We would also offer our plea papers as State's Exhibit 1, which contain the defendant's judicial confession, and the 3914 disclosures as State's Exhibit 2.
All right. Any objection to those exhibits being admitted, Mr. Hernandez?
No objection, Your Honor.
All right. State's exhibits are thus admitted. Ms. Rutledge, is there a plea bargain agreement?
Yes, Your Honor. The agreement is to sentence Mr. Martinez to 5 years TDC on each count to run concurrently.
To run concurrently? All right. Mr.
Yes,
Hernandez,
sir.
is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Hernandez, have you had an opportunity to review portal and all documents tendered to you?
Yes, Your Honor.
All right. Mr. Martinez, is this your understanding of the plea agreement in this case?
Yes, Your Honor.
All right. Understand the plea agreement is not binding on the court. However, should I reject it, I would permit you to withdraw your plea of guilty. If the court follows the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. These are the appeal rights explained in the trial court certification of your right to appeal, the original of which is signed by you, your lawyer, and will be signed by me, and a copy of which will be provided to you shortly. All right.
Yes, Your Honor.
Based on your plea of guilty and the evidence introduced, I will accept your plea at this time and find the evidence substantiates your guilt. I find you guilty of the offense of injury to a child, count 1, first degree, count 2, third degree, and count 3, third degree, and assess your punishment at 5 years in the institutional division of the Texas Department of Criminal Justice. The 3 counts shall run concurrent. Your sentence will commence this day, and you will be given credit for any time that you have spent in jail on these charges. Is there a victim impact statement, Ms. Rutledge?
There's not, Your Honor.
All right. Have I followed the plea agreement?
Yes, Your Honor.
Ms. Rutledge?
Yes, Your Honor.
Anything further from the state or the defense?
No, Your Honor, I just want to check one thing before I sign off on this case.
Nothing from the defense, Your Honor.
All right. With that, this concludes the matter on Mr. Martinez. And Mr. Martinez, they'll go ahead and they'll fingerprint you and give you copies of your paperwork, okay?
Yes, Your Honor.
All right, good luck to you, Mr. Martinez.
Thank you.
Thank you. All right,
May I be excused, Your Honor?
if you have nothing further from the court, Mr. Hernandez, you are free to be excused. You're free to leave. Annex, who do you have left?
There's quite a few, Judge.
Okay, who's next with them?
We can go ahead and start with Cristobal Carrillo. It'll be a bond hearing, Judge, on page 11.
And Leonardo, Mr. Nunez, I'm so sorry. You were actually the first person I called and then we lost you. I apologize.
Oh, it's okay, Your Honor. No worries.
All right, let's go ahead and Ms. Rutledge, are you ready?
Yes, Your Honor.
All right, let's go. Victor, go ahead and call the case. Let me ask before I start, did the judge want to start on the other case or is she wanting me to keep going?
I have not been told anything yet.
Okay, so then let's keep going. To Denise and Omar and Felix, they'll be with you shortly, and Scott Ferguson, they'll be with you shortly. Okay, so let's go ahead and start. Go ahead and call the case on Carrillo.
Yes, cause number 20210D01748, State of Texas versus Cristobal Carrillo. May I have announcement of counsel?
Good afternoon. This is Tara Rutledge for the state. The state is ready.
Luna Nunez from the Benjamin Law Firm here on behalf of Mr. Carrillo.
Mr. Nunez, I believe it's your motion.
Yes, Your
Wait,
Honor.
before I forget, are you seeing your client on the Zoom windows?
Yes, Your Honor, I do see him.
Okay, is he the individual in the labeled it with the annex?
Correct, Your Honor.
Okay, and are you going to be putting him under oath for any reason that I need to?
No, Your Honor.
Okay, so then Mr. Nunez, I believe this is your motion. Go ahead.
Thank you, Your Honor. Your Honor, our client is currently being held on a $100,000 bond. He's been incarcerated since June 9th, 2021. He currently has a 1-year-old son, and he just had another boy born 2 months ago, Your Honor. At the time of his incarceration, he was the only provider of his family. Since then, his wife has acquired a job, but it's been brought to our attention that she is still struggling and she does need some financial assistance. Mr. Carrillo did inform us that if he were to be let out, he still would have a job with gatekeeping Transmitarian. He did inform us that he could start immediately if he were to be let out. Now, we understand that these are some serious allegations being brought forth. And once these allegations came forth, Mr. Carrillo did decide to move out of the residence where the 70-year-old was at. He did start to reside with his brother at 52A Luna Azul Drive. He would go back to live with his brother if he is let out. Now, Your Honor, Mr. Carrillo has no prior incidences where he's been arrested. He's been a good member of the community. He wants to continue fighting these cases. He just wants to be able to do it while not being incarcerated. I do understand that right now everything is somewhat backed up, and I don't believe his trial setting would be one of the priority ones since other individuals have been in custody longer. Mr. Carrillo is willing to comply with any conditions that the court imposes on him. He is willing to report twice a week if he has to, and he has told me after a conversation today that he isn't even willing to be under an electronic device, which the court can do if you decide to let him out on a personal bond as well. We would like and humbly request a full PR bond, but if the court is not open to that, then we are requesting at least a reduction down to 50 to 60,000, which he would be able to post or his family would. Thank you, Your Honor.
Okay, Ms. Rutledge, you want to go ahead and
Oh,
let me know
yeah,
how
Your
this,
Honor. Yeah, so my main concerns obviously are the nature of the offense. It's very serious. I know he would not be allowed by the court to live with the complainant or the complainant's mother. But I do sense that he may be a flight risk. I don't believe he has very close ties to our El Paso community. I think that his mother actually lives in New Mexico. I don't know. I know, I guess that Mr. Nunez talked about possibly living with his brother. I don't know much about that, but I think the very serious nature of the offense and his limited ties to the community would really argue against having a full PR bond, although I would ask if there is a reduction in the bond, that there be some PR component to that so that, the court can stay in contact with Mr. Carrillo and ensure that he is reporting and not fleeing.
let me ask you, I'm showing 7 counts. Is that what your indictment is showing?
Yes, Your Honor. It's multiple counts.
Is it 7 though?
It's the same child, but yes, multiple counts against the same child.
And without a name, can you give me the relationship?
I believe it's a step parent relationship.
And so the mother of the 1-year-old and the 2-month-old is also the mother of the alleged victim?
I believe so.
That is correct, Your Honor.
All right. Correct me if I'm wrong. Is this one of those offenses where the offenses can be stacked?
They can, Your Honor.
All right, Mr. Nunez, these are charges are, I believe, still allowed by the code to be stacked. Their punishment can be stacked. And so when an individual is looking at that much possible time, I'm reluctant to lower the $100,000 bond. I believe if you want, you can revisit it in a few months with Judge Perez, especially if the state has not made movement towards being ready for trial. But this is an individual who, yes, while he's been in for 6 months, he's looking at, if they move to stack, which of course is their decision, he's looking at a substantial amount of time. All right?
Yes, Your Honor.
All right, so if in 3 months you feel the state hasn't moved towards resolution or preparation, then I think you can readdress this with Judge Perez, okay?
Yes, Your Honor. Thank you very much.
Thank you. You have a good day, Mr. Nunez. All right, what's next, Mr. Serna?
Yes, next one is on page 12, and that's Anthony Cortez, Annex.
Coming right up.
Good afternoon, Mr. Kennedy. How are you?
I'm good, Judge, now that I finally have internet.
Ah.
Had a power failure earlier.
All right. Mr. Kennedy, before we call the case, do you see your client in the Zoom windows?
I do, Your Honor.
Okay, is he in the window labeled Annex?
He is, Your Honor.
All right, Mr. Serna, go ahead and call the case.
Yes, Judge. Cause number 20210D02767. State of Texas versus Anthony Joel Cortez. May I have an announcement of counsel?
Kara Rutledge for the state. The state is ready, Your honor.
Brian Kennedy for the defense. The defense is ready, Your Honor.
All right, Mr. Kennedy, I believe it's going to be your motion.
It is, Your Honor. Mr. Cortez does have strong ties here in the community. He has been incarcerated now for 58 days. We were ready to go to trial, and then some pre-files were transitioned over that had taken a while to process. So we were back at step one. The initial charge was earlier this year, and he had been out for almost 4 months and had reported whenever he was supposed to report. He does live with his parents at 436 Northeast Bryan Street, Fabens, Texas. And he does have a job at Expeditors International that they're holding for him at this point. We do understand that there would be no contact at all with Leslie Brian Ochoa, which is the CW on this. And we would ask for a PR bond, but if the decision was made to not go on a PR bond, that he be given a $20,000 bond, which he and his family would be able to raise the funds to cover. Like I said, he is living with his parents and he has a job there, so his flight risk is limited or none at all. And the second incident in question actually happened at his house. He didn't go somewhere and look for someone. He does have a child with Miss Ochoa, and he is willing to forego visitation of that child until we are able to fight this one out and come to a conclusion. He just wants to get back to working and back to his life, Judge.
Ms. Rutledge, what says the state?
So, Your Honor, we are opposed to any bond reduction in this case. The defendant has 2 cases pending before the court. One, a 2020 case where the alleged victim is his child, Alyssa Cortez. And then this case involves the mother of that child, Leslie Ochoa.
So is he, okay, so let's go back. Is he booked on two cases?
There was a surrender or an affidavit of incarceration filed in the 2020 case. I don't know if Mr. Kennedy is seeking a bond reduction on that, but he was, I believe, incarcerated on that based on the bonding company's affidavit of incarceration.
What's the cause number on that 2020? Because it's not on my docket.
Your Honor,
Do you have it, Ms. Nieto?
yes.
It's 2020
booked on-
ODO. I'm sorry, go ahead.
He's booked on both cases, 2021, 2767, 60,000 cash or surety. Is the
60?
bond 60,000? And
Okay.
on 2020, 3566, that was a bond surrender from his bonding company. And that one is set at 100,000. So total bond is 160.
He was out on the original. It was a $10,000 bond. And then when there was the incarceration from the bond company and the surrender, the new bond that was put on there was 100. I'm actually looking for a reduction of both of them jointly.
Okay. Well, let me tell you, I only have the 2767 on the docket right now. Did you file a motion on both of them? Was the motion filed on both?
They were supposed to both be filed at the same time, Judge.
Marissa, do you see a motion to reduce bond on both cause numbers?
I'm looking at it right now, Your Honor. Just a moment, please. On the 2020 case, I do not see a motion filed.
So let me make sure I understand this. He's out on 2020 3566. He's out on bond on that. And then he picks up a new offense with the mother of his child as the new victim. And he's now on a $60,000 bond for the second one. Is that what happened?
Let me see.
Yes, Your Honor.
I believe that's correct, Your Honor.
Okay. All right, Mr. Kennedy. So he didn't do real good on bond the first time.
I understand that, Your Honor. It was an incident that, like I said, this happened at his home. The mother of his child actually had gone to his house. The quote was ostensibly to pick the child up, but that's when the confrontation happened at his home. So he wasn't searching her out, going to her house. This is one where she came to the home, and that's when the incident took place.
All right, let me go back to Ms. Rutledge. Do you have anything further, Ms. Rutledge? I didn't have the amounts before, so I needed to get those.
Of course, Your Honor. So I just want to advise the court that he was out on bond for the 2020 offense that involves an injury to the child, Alyssa Cortez. Now, the charges in the 2021 case are for continuous family violence And that is because on April 5th of 2021, when Ms. Ochoa went to pick up her child from his home, because he didn't have a PR bond, he had a surety bond, so there were no conditions regarding contact with the child. The defendant's alleged to have sort of been flirting with her. She didn't pay attention to his advances. And as she started to drive off, he hit her on the nose and the mouth with a fist 2 times. The other charges that relate to the continuous family violence also contain the elements of the assault on a pregnant person and the obstruction or retaliation. And these happened on October 16th of 2021. Again, Ms. Ochoa went to pick up her daughter from his residence. He became upset. He punched her. She had a bruise on her right eye. She was bleeding from a cut on her bottom lip. She was bleeding from a cut on her hand. And she also had redness on her arm. The defendant was angry when she went to pick up the child. He punched her. When she was knocked to the ground, he continued to punch and kick her. So that forms the allegations of the continuous family violence. She's 15 weeks pregnant, so that is the basis of the assault on a pregnant person. And during the course of this assault, he went to get his gun and threatened to shoot her if she reported the incident.
Okay, so let's go
these
back.
allegations-
She's 15 weeks pregnant.
Yes.
Is it alleged she's pregnant with the defendant's child again, or is somebody else?
No, just that she's pregnant. I don't know whose child it is, but
Okay.
the allegation is that he struck her while she was 15 weeks pregnant. And then he threatened her to shoot her if she reported the incident. So we're opposed to any reduction in the bond. Not only did he commit one offense while on bond for an injury to the child, he's committed 2 assaults against the complainant, who is the mother of that same child. He's also threatened her life for reporting it, and she's 15 weeks pregnant. These are very serious allegations, and we're opposed to any reduction at all in bond.
This is the thing. He's got a combined bond of 160. So I believe that's a little much. I don't think I'm coming down a significant amount, but I do believe a combined 160 is a large amount.
Okay.
I'm
And Your
trying to,
Honor, if you do reduce the bond, given the fact that
I will
that
add
we have
PR,
PR, thank you.
and I will obviously add no contact with either of the CWs. This
Thank
is the
you, Your
thing.
Honor.
This is the thing, though. I'm trying to figure this out logistically because 3566 does not have a motion on it. And so he's still got the 100,000. You're entitled to, see, he doesn't have a motion on it. You would be entitled to your notice, Ms. Rutledge, if I reduce that one.
I understand, but I also respect Mr. Kennedy, and if he's saying he intended to file it in both, I don't see any reason why he wouldn't file it in both. And so there must have been some sort of clerical snafu. I mean, if he could ensure that there is a motion filed or his office sends it in, because the motion was filed back in November, Your Honor. So I don't see why he.
Right, the additional one was
I-
added as soon as we got
Right.
the paperwork that the 10,000
Right.
had been surrendered.
So
I will
I
make sure
trust
that
his
that is filed in.
representation. Yeah.
All right.
Thank you, Ms. Rutledge.
Okay, well, so based on the fact that you're going to go ahead and allow the hearing to be on both 3566 without an objection, I'm going to go ahead and go to 70,000 on 3566, 70,000. With that 70, I want a 30 PR on that. With that PR, no contact with the CWs from both cases, and I want weekly reporting. On the 2767, I'm going down to 30,000. Also with the 30 PR. With the same conditions, no CW, no children, weekly reporting. I also want a curfew. There's no reason why Mr. Cortez needs to be out past 9 p.m. If it's work-related, he must provide proof that it's going to be work-related. All right. Ms. Nieto, I went really fast on that. Did you get it all?
I believe so, Your Honor. 30-30 and, sorry, 70-30 and 30-30, no contact with CW, no children, weekly reporting and 9 p.m. curfew.
Yes.
And so, Your Honor, that's like absolutely no contact, no appearing at the residence, no appearing at the, it's kind of similar to a protective order at the
Correct.
place of work or
Oh.
anything like that.
He needs to, the firearms, no firearms. Mr. Kennedy, he needs to
Surrender.
surrender. Well, it's not a conviction yet. There can be no firearms in the home, Mr. Kennedy.
I understand, Your Honor.
Okay. Also, burden is on him. If he enters a store and they're there, burden is on him to leave. Same thing with if this victim shows up at his home, burden is he stays in the home and calls for assistance from 911. Okay?
I understand, Your Honor.
All right. Have a good talk with him, Mr. Kennedy. Make sure he understands what behaving is. I went ahead and went with this because 160 was just too much. But I didn't make it easy either.
I understand, Your Honor.
Okay. Anything further from either side?
Your Honor, just with regard to the firearm, I know that Mr. Cortez obviously is in custody, but can we receive assurances that there are no firearms in the home before he's released to his home? I mean, our complainant
I'll
is
make that very clear to my client.
And well, she's you know, she's scared of him. These are serious allegations. I realize they happened at his home, but he's very violent. And so I do have concerns about that. And I don't know who's in his home that can take possession of that or who he trusts to take possession of his firearms, but I would like some assurances before he's released.
I will get that assurance for you before he's released.
All right.
Thank you, Mr. Kennedy.
All right.
And
Burden is on him.
Ms. Rutledge and Judge, I just reached out to my admin and don't know what happened, but that'll be pushed back through on the filing within the next 5 minutes.
Okay, that's fine. Thank you, Mr. Kennedy. I appreciate it. Mr. Kennedy, talk to your client. I mean, this wasn't an easy decision. It was just really based on the fact that 160 was a large amount.
I understand, Your Honor.
Okay.
I will sit down and make sure, Anthony, I'll come out and talk to you.
All right. All right, Mr. Kennedy, anything further?
Nothing further, Your Honor.
All right, anything from the state?
No, Your Honor.
All right. Okay, we are adjourned on 2021-0D0 2767.
Thank you, Judge. May I be excused?
Yes, you may.
Go ahead, Senator.
All right. Mr. Serna or Chris, where are we at now?
Annex, can I have Luis Valdez for Mr. Carmona? Page 15, Judge. And this is a bond hearing.
Correct. Mr. Valdez?
Yes, ma'am.
Mr. Carmona, do you see your client in the Zoom windows?
Yes, Your Honor.
Is he the one labeled at annex?
Yes, Your Honor.
All right. Let me go ahead and Victor, go ahead and call the case.
Judge. Cause number 20210D02442, State of Texas versus Luis Valdez. May I have announcement of counsel?
Tara Rutledge for the state. The state is ready, Your Honor.
Omar Carmona for Luis Valdez. Ready, Your Honor?
Mr. Carmona, I believe it is your motion.
Yes, Your Honor. I don't know how you like me to proceed. We were here about a month ago for a bond hearing, and Judge Perez had lowered it, but she had indicated that she would revisit lowering it further, or even I was going to ask for a PR bond, but she did say she would consider possibly lowering it depending on the status. This morning, we had a hearing, and Mr. Murphy for the state was present online, and he had indicated that the district attorney's office still had not followed up with their complaining witness. So I am asking the court to grant my client a PR bond. Your Honor, we have two different addresses for my client. I think I gave them both at the last bond hearing. So if the court feels comfortable, so he wouldn't be anywhere near the complaining witnesses in this case, he'd be living at the other address, Your Honor. Is that right, Mr. Valdez? You'd be living with your sister?
Yes, sir.
Okay, and so he would be away from the complaining witness. That address is on, it's 221 La Mirada, Mirada, and for the reason that the state has still not followed up with the complaining witnesses in this case, we're asking the court for a PR bond, Judge.
Okay, a couple of questions for you, Mr. Carmona, before I go to Ms. Rutledge. What is the bond amount currently?
I believe it's lowered to 50,000. Is that right, Mr. Valdez?
49.
It's 49?
49.
Your Honor, it is a 49,000 cash charity, 1,000 PR, reporting once a week, regular restrictions, 9 p.m. to 6 a.m. curfew, no contact with complaining witness, give sample of UAs upon request, use no illegal drug or alcohol, not allowed to leave El Paso County, no new offenses, report place of residence to PR, and have no possession of weapons.
Okay. And then I'm assuming it's a romantic CW,
No.
but can you verify for me, Mr. No?
It's not, Your Honor. No.
Who is it?
A neighborhood family. Family
it's
and
bickering neighbors?
yes, Your Honor.
And so that's why the addressing becomes an issue.
Yes, Your Honor.
Got it. Okay. Okay, so Ms. Rutledge, you weren't here in the morning. Mr. Murphy handled it. This case got arraigned on October 19th, 2021. And as of today, there has been no rec given.
Okay.
All right. I don't recall what Mr. Murphy said in regards to the CWs. So if you can provide in your summarization, if you can provide me with information about the CWs, that would be great.
Okay, so the CW, the victim is actually a child. He's 14 years old. There's sort of a party situation going on. He was visiting his girlfriend who lived at the Lisbon address. There's some sort of disagreement, and the defendant, I believe, is the girlfriend's father or something. There's allegations that there's a disagreement between Destiny, who is the defendant's daughter, and others at the party. And then the victim was attacked. He was hurt. He was hit. He was threatened with a firearm. And that's why we have all of these. In addition, the defendant has been to the pen. I believe it was for a DWI, but I could verify that. So he's not allowed to be in possession of a firearm.
It was for drugs.
For drugs. Okay, I knew it wasn't a violent offense in particular. So he's no longer on parole for that. However, this happened shortly after his release from parole because he was sentenced to 6 TDC back in 2015. And then because that's less than the 5 years, he's charged with unlawful possession of a firearm by a felon. That's kind of the gist of it. So just given the violent nature of the offense and in the actions that occurred, including the allegation of possession of a firearm by a felon, we are concerned because obviously this defendant, if found guilty, is looking at a higher than usual sentence due to the enhancement. With regard to our contact with the complainants, we have been reaching out. We have requested better locates. We have sent out a 5-day letter. I believe that was sent out in November, but we have not heard back. So it's not that there's been no action taken regarding the complainants. It's just that we've had an inability to communicate with the complainants.
Okay.
And I understand the seriousness of what Ms. Rutledge is getting into, Judge, but my client is adamantly denying that this story of him being in possession of a firearm and essentially pistol whipping another individual it's an outright lie. So that's why my client is adamant.
Were the injuries sufficient enough to require hospitalization?
He did get stitches, Your Honor. I don't know that it was more than that, like in terms of like an overnight stay or anything like that, but the complainant did get stitches.
Well, and as a matter of fact, I believe Judge Perez is starting to join us. I don't know if she's exactly ready to come in yet. I'm going to say that my concern is that this is an individual who was arraigned, if I can find it again. Give me a second. He was arraigned on October 19th, 2021, and has not received a rec.
Right, and I can provide a rec. There was some delay in the case, Your Honor, because of some difficulty linking the case, and I'm sure Mr. Carmona can confirm this. It wasn't linking through portal, so nobody really had access to the facts of the case or the complainant's contact information. And so we are still, looking at contacting him. But if we want a rec, I can recommend I think 15 TDC at this point, just based on the enhancement and the facts of the case. I think they warrant a TDC rec. The complainant, I know you asked me about this, he did go to Sierra Providence and he received multiple staples. I don't have any information that he was admitted, but he did have a laceration requiring medical treatment.
Mr. Carmona, you have a lot in your favor, and then she reminds me he's got a pen packet. That's where she.
Yes, Your Honor, and Ms. Rutledge is correct that there was an issue with getting all the information to portal, but unless another supplement was added, I don't believe a weapon has ever been recovered. And again, Your Honor, we are just adamant that this is a fabricated story, that the individuals, we believe that the complaining witnesses in this case and their associates were are gang members. It wouldn't surprise me if they made this whole thing up, but no weapon was recovered, Judge.
Where would he be living again?
With his sister on La Mirada.
Where is that in relation to Luna?
Valdez, how far is that?
That's, Luna is on the northeast side, and I live on the west side. We're off the Redwood.
Mr. Carmona, does he understand that if I do reduce this bond, he is not to return to the capacity of Luna at all?
Mr. Valdez, is that crystal clear to you?
Yes, sir, it is.
That you would be thrown in jail if there's any problems with you being anywhere near that neighborhood?
Yes, sir.
He understands, Your Honor. I've known him for many years.
All right, I'm gonna go a little bit lower, not going all the way, definitely not going all the way PR. I'm gonna do 35 cash, and I'm gonna do 15 PR. As a condition of those PR, no contact with the CWs, no proximity to the home located on Luna. Again, burden goes to him. He sees the victims, he needs to step away, he needs to walk away. I want a curfew and I want weekly reporting. I want UAs and BAs. So I want him to be sober while he's out there. Okay, Mr. Carmona, normally you don't add the UA and the BAs to the assaults, to the assaults, but I want him to be sober out there.
Yes, ma'am.
All right. This was a tough call. But the CWs need to make contact. So let's see if this makes them reach out.
Thank you, Judge.
All right. Ms. Rutledge, I'm sure you're not thrilled, but.
I mean, it is what it is, Your Honor, and we will continue to make efforts to reach out to our complainants.
All right, good luck with that.
Mhm.
All right, good luck to you, Mr. Valdez. This concludes the matter on 2021-0D02442. I'm assuming there is nothing further, correct?
Nothing from the state, Your Honor. Thank
She's
you.
already on.
Nothing from Mr. Carmona?
Nothing further. Thank you.
All right. And Mr. Serna, I believe this
Well, you
concludes
should, since you're already.
my matters, correct?
Yes, Judge, that is correct. Mr. Spencer never came on. I don't know of whether he's going to or not, because this is the next hearing out of the annex was pre-revo. So I don't know if he was notified to be a part of this hearing. So no, Mr. Spencer.
Okay, all right. I'm going to go ahead and turn off, but I'm staying in so that I can be chatting with Ms. Nieto, reference my signing of judgments. But I will be turning off camera and turning off audio, okay?
Thank you, Judge.
And
Judge,
Your Honor, I'm sorry, am I excused as well? And I know that Ms. Nieto can reach me via email or Teams if she needs anything.
Ms. Rutledge, if you have nothing further with the court, I am excusing you.
Thank you, Your Honor.
Thank you. Judge Perez.
Hi, Judge Reyes. I
Hi.
just checking. I didn't mean to interrupt. I wanted to let you finish what you were doing. Was that the last individual?
With the exception of those that did not appear, yes, Your Honor.
Oh, thank you. Thank you, Judge. I appreciate your help.
Okay, well, I
you're
reduced a few
welcome.
bonds, Judge, so I'm not sure how helpful I was for you.
Judge, I trust you. That's why you're here.
Thank you, Judge.
I
All right,
appreciate
like I
your
said, I'll still be nearby because I've got Ms. Nieto via chat with her, okay?
Thank you very much.
Thank you.
Judge Perez, may I go ahead and excuse Ms. Garza?
Miss Garza, yes, is Erica here?
Yes, she's
Yes,
on.
yes.
Oh, there she is. Okay.
Okay, Judge, thank you so much.
Miss Garza, thank you also. Thank you for being here.
You're welcome. I'll be back tomorrow.
Okay,
All
appreciate
right,
you.
thank you.
Okay, let me just look. I've been in real in-person land, so let me see. Okay, all righty. Is it Mr. Serna, are you handling this? Yes?
Yes, Judge.
Okay,
We're on page 14.
let's get started.
Yes. Cause number 20210D02909, State of Texas versus Ivan Gabaldon. May I have announcement of counsel?
Your Honor, for the state, Curtis Cox and Scott Ferguson.
Good afternoon, Judge. On behalf of Mr. Gabaldon, it's Denise Butterworth, Omar Carmona, Felix Valenzuela.
Okay, that audio sounds a little different, Miss Butterworth. I'll let you know if we have any issues, or maybe it's just me, but sometimes we have those internet issues. And so Mr. Gabaldon, it looks like he is appearing from the downtown jail. Let me pull up the case on Odyssey. All right, good afternoon. And let's see, we are scheduled for a status hearing. First of all, I want to, I don't know if so much as apologize, but just thank you for your cooperation with the court scheduling as, I don't know, defense counsel in this case knows, but I know the state probably knows that the 10th is in trial and we are handling matters, and it was just a little complicated logistically to take care of matters, so we were unable to have our hearing yesterday. Luckily, we had the backup setting for today, I guess. And my understanding was the parties were in agreement to not, or to go ahead and jump over to today's hearing instead of yesterday. So thank you all for that. As you all are well aware, we are pending the state's, the defense motion to dismiss. And thank you to each of you for providing me with state, the additional supplement and proposed findings, as well as the defense providing proposed findings. I just need to ask at this point if there is any, I've read everything that you all have sent me, and obviously been present for all of the hearings that we've had. So I've reviewed everything up until this point. I guess I'm just asking if either side has anything more to present to the court. Mr. Ferguson, you are muted.
Thank you, Your Honor. The state filed the statement by Patricia Valenzuela. And I did want to move to admit that into evidence for purposes of this hearing. because I know we talked about it a lot. But just so that you got the actual physical statement there to see what we're talking about.
You don't have an objection to that being part of the record, Judge.
Okay, and I did see that. I didn't note it specifically, but yes, I did review it, and it will be admitted for purposes of the record for today's hearing.
Thank you, Your Honor.
Anything else?
At this point, Your Honor, I think we've all said everything that I think both sides have covered so exhaustively that for us to continue to go back and forth would just be wasting breath. So.
Well, again, considering the seriousness of this matter, I want to convey to you all that it has, as I'm sure as equally as it has weighed on all of you, it has on me as well. And so I agree, Mr. Ferguson. I think we know where we are at this point. Having reviewed and listened to the arguments or the reasoning of the state of Texas regarding what I think I have characterized as two decisions, but I think ultimately we're talking about, I don't know where that noise is coming from. Actually, downtown jail, I think that's what I saw light up. Could you, yeah, they just muted. Okay.
I just muted it, Judge.
Thank you. There are several points that the defense has brought up or highlighted, but clearly I was present for all of those hearings and I saw the proceedings transpire as they did. I simply find the state's reasoning and explanations for its decision to re-indict and ultimately seek the death penalty is not credible. I am therefore granting the defense motion to dismiss for prosecutorial vindictiveness. I am very concerned. I am very concerned and have been concerned for a while because of the lack of diligence that the state of Texas has, the manner in which they've been handling, you all have been handling these cases. It is with no pleasure whatsoever that I am looking at this case and just feeling in my years as a prosecutor and being in this courthouse, I certainly did not expect to be in a position to see the state of Texas literally disregard some of the most serious cases, to include this one, but as I know that there are others in this court that follow the same fact pattern here, very similar circumstances. And I'm not sure how we got here. Well, I actually am sure how we got here because I've seen it. And it does not in many ways feel like justice, because at the end of the day, we are dealing with circumstances and allegations that are very serious. There are families of victims that are not being well served when cases within the DA's office can just be disregarded. And there are so many troubling things. I agree. I'm not going to reiterate, but I do feel that the defense has provided sufficient evidence that the re-indictment and the decision to seek the death penalty was an unjustifiable penalty resulting solely from Mr. Gabaldon's exercising his right to go to trial. And so I have a proposed order of dismissal. I will be signing that and filing it today. Thank you very much. I guess we're concluding this hearing. Thank you. Mr. Brackeen, we can go ahead and get off of YouTube at this point.
You got it, Judge.